Let's talk about the foreign trade zones. Foreign or free trade zones are secured areas legally outside a nation's customs territory. Their purpose is to attract and promote international trade and commerce. The Foreign Trade Zones Board authorizes operations within these zones, based upon showing that the intended operations are not detrimental to the public interest. Subzones are special-purpose facilities for companies unable to operate effectively at public zone sites. Foreign trade zones are usually located in or near customs ports of entry, at industrial parks, or terminal warehouse facilities. Foreign trade zones must be within 60 miles or 90 minutes driving time from the port of entry limits, while subzones have no limit and are located in the zone user's private facility. A Foreign Trade Zone Board, created by the Foreign Trade Zone Act of 1934, reviews and approves applications to establish, operate, and maintain foreign trade zones. It is important to note that, although foreign trade zones are treated as being outside the customs territory of the United States for tariff and customs entry purposes, all other federal laws, such as Federal Food, Drug, and Cosmetic Act, are applicable to products and establishments within such zones. Foreign exporters planning to expand or open up new American outlets may forward their goods to a foreign trade zone in the United States to be held for an unlimited period, while awaiting a favorable market in the United States or nearby countries, without being subject to customs entry, payment of duty or tax or bond. Treatment of goods. Merchandise lawfully brought into these zones may be stored, sold, exhibited, broken up, repacked, assembled, distributed, sorted, graded, cleaned, mixed with foreign or domestic merchandise, or otherwise manipulated or manufactured. However, merchandise imported for use in the zone, such as construction material and production equipment, must be entered for consumption before it is taken into a zone. The Foreign Trade Zones Board may determine, however, that an operation is not in the public interest. The resulting merchandise may, thereafter, be either exported or transferred into the customs territory. When foreign goods, in their condition at the time of entry into the zone, or after processing there, are transferred into the customs territory of the United States, the goods must be entered at the Custom House. If entered for consumption, duties and taxes will be assessed on the entered articles, according to the condition of the foreign merchandise, at the time of entry from the zone, if the merchandise has been placed in non-privileged foreign status, prior to manipulation or manufacture. The owner of foreign merchandise that has not been manipulated or manufactured in any way that would affect a change in its U.S. tariff classification had it been taken into customs territory when first imported, may, upon request to the Port Director of Customs, have its dutiable status fixed and liquidated. This dutiable status will apply regardless of when the merchandise is entered into customs territory, and even though its condition or form may have been changed by processing in the zone. Merchandise may be considered exported, for customs or other purposes, upon its admission into the zone. In zone-restricted status, however, the merchandise taken into a zone under zone-restricted status may be for the sole purpose of exportation, destruction, except destruction of distilled spirits, wines, and fermented malt liquors, or storage. An important feature of foreign trade zones for foreign merchants entering the American market is that the goods may be brought to the threshold of the market, making immediate delivery certain, and avoiding possible cancellation of orders due to shipping delays after a favorable market has closed. Production of articles in zones by the combined use of domestic and foreign materials makes it unnecessary to send the domestic materials abroad for manufacture, or to pay duty, or obtain a bond for foreign materials that have been imported for this purpose. Duties on the foreign goods involved in such processing or manufacture are payable only on the actual quantity of such foreign goods, incorporated into merchandise transferred from a zone for entry into the commerce of the United States. If there is any unrecoverable waste resulting from manufacture or manipulation, allowances are made for it, thereby eliminating payment of duty, except on the articles that are actually entered. If there is any recoverable waste, it is dutiable only in its condition as such, and in the quantity entered. The Foreign Trade Zone Act also authorizes the exhibiting of merchandise within a zone. Zone facilities may be utilized for the full exhibition of foreign merchandise without bond for an unlimited length of time and with no requirement of exportation or duty payment. Thus, the owner of goods in a zone may display the goods where they are stored, establish showrooms of her own, or join with other importers in displaying his merchandise in a permanent exhibition established in the zone, and since the importer may also store and process merchandise in a zone, he is not limited to mere display of samples, but may sell from stock in wholesale quantities. Retail trade is prohibited in zones. Domestic merchandise may be taken into a zone and, providing its identity is maintained in accordance with regulations, may be returned to customs territory free of quotas, duty, or tax, even though while in the zone, it may have been combined with or made of other articles. However, domestic distilled spirits, wine and beer, and a limited number of other kinds of merchandise, generally, may not be processed while in the zone. What are some of the advantages for foreign trade zones? Savings may result from manipulations in manufacture in a zone. For example, many products shipped to the zone in bulk can be dried, sorted, graded, or cleaned and bagged or packed, permitting of savings of duties and taxes on moisture taken from content, or on dirt removed and culls thrown out. From incoming shipments of packaged or bottled goods, damaged packages or broken bottles can be removed. Where evaporation results during shipment, or while goods are stored in the zone, contents of barrels or other containers can be regauged, and savings obtained, as no duties are payable on the portions lost or removed. In other words, barrels or other containers can be gauged at the time of transfer to customs territory, to ensure that duties will not be charged on any portion of their contents lost to evaporation, leakage, breakage, or otherwise. These operations may also be conducted in bonded warehouses. Savings in shipping charges, duties, and taxes may result from such operations as shipping unassembled or disassembled furniture, machinery, etc., to the zone and assembling or reassembling it there. Merchandise may be remarked or relabeled in the zone, or in a bonded warehouse, to conform to requirements for entry into the commerce of the United States if it is otherwise up to standard. Remarking or relabeling that would be misleading is not permitted in the zone. Substandard foods and drugs may, in certain cases, be reconditioned to meet the requirements of the Food, Drug, and Cosmetic Act. There is no time limit as to how long foreign merchandise may be stored in a zone, or when it must be entered into customs territory, re-export, or destroyed. Transfer of goods in bonded warehouses. Foreign merchandise in customs bonded warehouses may be transferred to the zone at any time before its retention date in the bonded warehouse expires, but such a transfer may be made only for the purpose of eventual exportation, destruction, or permanent storage. When foreign merchandise is transferred to the zone from customs bonded warehouses, the bond is cancelled, and all obligations regarding duty payment, or the time when merchandise must be re-exported, are terminated. Similarly, the owner of domestic merchandise stored in Internal Revenue bonded warehouses may transfer his or her goods to a zone and obtain cancellation of bonds. In addition, domestic goods moved into a zone under zone restricted status are, upon entering the zone, considered exported for purposes of excise and other internal revenue tax rebates. A manufacturer operating in customs territory and using dutiable imported materials in his or her product may, upon regulations, also obtain drawback of duties paid or cancellation of bond. Location of and general information on United States foreign trade zones may be obtained from the Foreign Trade Zones Board, Department of Commerce. Questions relating to legal aspects of Customs Service responsibilities in regard to foreign trade zones should be addressed to Chief, Entry and Carrier Rulings Branch, U.S. Customs Service.